So assuming you've hired us and we could not get your claim settled, okay, now that's either because the insurance carrier was not reasonable in their offers, happens all the time, unfortunately, or the time limit to file a lawsuit is now upon us, but you're not medically stationary. You're still treating, you're still getting treatment, therapies, perhaps surgery, your post-surgical recovery. We don't know what your future holds, nor do your doctor. So it's really difficult to assess the value of a claim if you're still treating and we don't know if you're gonna need, 5 more months of treatment versus 5 years versus some permanent injury, right? So at that stage, because there's a hard and fast time limit to file the case to preserve it, it goes to the litigation side of our firm. I run the litigation side. So it comes to my desk and I work with 3 other litigation lawyers in the firm, and one of us will then draft the lawsuit and get it filed. And what that does is it preserves your right to continue the negotiation process and seek recovery from the adverse party and their insurance carrier. Without doing that, if that deadline passes, you now have no claim whatsoever. You're not allowed to go back and claim $1. So we have to get the lawsuit filed within that time frame. It's called the statute of limitations to preserve the claim. And once that happens, there's more formal channels that kick in because the court has deadlines and various procedures that we have to follow. So the litigation team files it. We serve the lawsuit on the adverse party, and oftentimes on their insurance carrier too. We send out formal requests to produce various documents. Those are things like property damage estimates, photographs of the scene, statements of witnesses, statements of our client, so on and so forth. So there's a laundry list of stuff that we ask for. And oftentimes they're doing the same thing with us. They're asking for things that we would have on your behalf that we have to produce to them in the discovery process. Once those paper documents, right, the papers and the photographs and whatnot are exchanged, then generally we move on to what's called a deposition phase. And that means that we now have the documents in hand, we know what the case is about, we know what the factual underpinnings are, at least as best we can tell from the documents. Now we're gonna go ask questions of the other side. Okay, that's called deposition. You're under oath, you swear to tell the truth, the whole truth, nothing but the truth, so help you God, I do. And then the attorney asks you questions. And usually that's about a 2 to 3 hour process for most plaintiffs. Our clients is a little bit shorter for the defendants because we don't have to go into medical history or treatment because usually they're not injured. It's just a matter of, let's say, a car crash. How fast were you going? What did you see? What did you do? Why did you hit my client? How bad was the property damage? Did you observe any injuries on my client? Did you talk to my client? What did they say? Do you know of any witnesses? What are their names and addresses or other contact information? So there's a lot to ask of these people, but it doesn't take as long as our client because our client is asked about more topic areas, specifically their prior health history, their subsequent health history, their treatment status, how they're doing now, how their life is affected because of their injuries, those types of questions that the defendant wouldn't get asked. And then generally speaking, because each case is a little bit different, but for the most part, it's right in the middle of the Bell diagram, okay? After the discovery phase, so that means the request for production of documents and the depositions are done, then there is an evaluation phase for the insurance company and then a negotiation phase. And so that can take place via traditional negotiations, emails or phone calls or letters back and forth, or what's kind of become the norm is a mediation process where we hire a mediator to come in. I generally try to make the insurance company pay for the mediator, but the mediator comes in, he or she is usually a retired judge, and they will then try to broker during the course of a day a settlement deal between the two sides who are in 2 separate rooms who can have private conversations with the mediator, and any information shared with the mediator doesn't go to the other room unless we give them permission, so it's all confidential. And the other side has the same confidence. And then we can be as honest and as frank as possible and really try to get this thing to the position it needs to be in. Usually that involves a lot of struggle in the other room or the mediator's beating the insurance carrier over the head until they finally give up and come up to a number that makes sense. But generally speaking, in about a day, anywhere from 4 hours to 8 hours, usually closer to 4, we can get the thing resolved in mediation. And if it's not resolved in mediation, then we're just gearing up for trial at that point. Sometimes cases that don't resolve in mediation do resolve short of trial. Oftentimes they don't. We have to go try the case. And that's the benefit of hiring our firm is you got a bunch of trial lawyers that love to try cases at your back. And if we got to go to trial, baby. And game's on.